Patty. I'm head of Joshi Advocates. Thank you very much for joining us in our Halloween trick-or-treat video. So in the next 5 minutes, we'll look at spouse visa, where someone is married to a qualifying sponsor, British, settled, pre-settled European, refugee or HP, but they are not lawfully resident. So the applicant is not lawfully resident, but is married to a qualifying sponsor. So in the next 5 minutes, we'll look at what to look out for in the application and how to make a confident application, right? So there are 5 spouse visa requirements, right? 1, the relationship. So is the relationship genuine and subsisting? Are we living together? Are we married legally? So that's 1, supported by documentary evidence, right? Marriage certificate, documents to show we're living together, bills, bank statements, photographs. Sorry. So yes, the first requirement we just did, forgive the interruption, was relationship. The second requirement is the financial requirement, where the sponsor must be earning 29,000 annually in a job from employment they kept for at least 6 months, earning the same or above, or they're self-employed. For the purpose of this video, their profit in the tax return is 29,000 plus, right? Keep in mind the financial requirement is slightly higher if the sponsor is sponsoring the applicant spouse plus a child dependent, right? So just take legal advice on that and the exact income that's meeting the threshold. So that's the financial requirement. The third requirement is a maintenance requirement, where the sponsor will show the tenancy agreement or the title deed that they own the property, right? And the final requirement is English language A1 certificate. Now, let's say that the sponsor meets all of those requirements, right? But the final requirement is whether the applicant is lawfully resident in the UK, right? So here the glitch is, or the trick or treat is, that just because we are married to somebody who is a British or settled or a qualifying sponsor does not mean that we will get the UK spouse visa, because there are 4 requirements to meet that we've just gone through. Additionally, the 5th requirement, that is, we need to be lawfully resident in the UK, right? Because if we're not, and we submit the application in the UK meeting all those 4 requirements but unlawfully resident in the UK, then the Home Office will say, that's great, you meet all the requirements, but leave the UK and apply to come in, or take your sponsor spouse with you and have them live there in the country of nationality. So when you make this application for a spouse visa, address this point, that I'm not lawfully resident, but there are exceptional circumstances. This is the treat in this video. The exceptional circumstances why I can't leave the UK and apply to come in as a spouse, and or why my sponsor spouse can't live with me in that country of nationality, so we can't enjoy our family life anywhere except the UK, right? So now the question is, what are exceptional circumstances that makes a confident UK application? There is no set ABCD formula, right? Because it depends on the caseworker's discretion. So the caseworker can say, yeah, they're exceptional, but still no, refuse. They can, right? Because it's a human approach. Or the caseworker can ask for documents to support the exceptional circumstance. Do not wait for the caseworker to ask for documents. Provide the documents to show that, for example, my sponsor has medical conditions and I provide care, but here, address the weakness in this argument. The Home Office will say, yeah, the NHS can provide the care. You don't need to be here. So address why you need to be here so that your sponsor is cared for reasonably, right? And address if the NHS can look after or not. So again, GP medical documents will be very, very useful and relevant. Another example would be there's mental health conditions. Another example is I can't leave the UK because it's not safe in that country. Now, if you're saying it's not safe, possibly making the spouse visa application is not the correct procedure. More likely, the relevant procedure would be to claim asylum and raise the partnership in the asylum claim within the human rights considerations, right? But take legal advice on that point. Another reason would be, for example, I have my sponsor partner is looking after someone who is like her elderly ill mother, and she can't leave the UK, and I am supporting the sponsor emotionally. There's dependency. We've lived together for a long time. We've sort of grown attached. I mean, there are many different scenarios, right? So again, take legal advice to see if your situation meets the exceptional circumstance threshold. The threshold is not that we don't want to go and apply for entry clearance. the threshold is we can't go, yeah, because otherwise Home Office will say you are choosing to make the application in the UK whilst you are in the UK in breach of immigration rules because you've overstayed, right? So that's the unattractive side of the application as far as Home Office sees it. You need to then show why that requirement of exceptional circumstances can be met, right? Now, I hope that's been helpful as a trick or treat video, because I know we've had so many phone calls where people have been caught by this CILEx case and they're married to someone who is a qualifying sponsor EA national, settled or pre-settled, but they're unable to regulate their stay under the EU settlement scheme because of the CILEx technicality. So the way moving forward would be to take legal advice on the spouse visa before you make the spouse visa application, right? Because that spouse visa is under immigration rules, not European. Take advice on how long it takes, how much it costs, and the chance of success, yeah, based on those 5 requirements. So I hope that's been helpful. As always, contact me, details below, subscribe, and happy Halloween. Take care. Bye.